The wait is over. The permits are dead. And if you have been watching this channel, you have been waiting for this moment since Carson versus United States wiped out permit systems, and states immediately began building replacement schemes to recreate what the Supreme Court told them they could not have. California called it the Firearm Responsibility Certification. Illinois called it the Responsible Citizen Firearm Registry. New York built its Community Safety Firearms Enrollment. New Jersey created its Enhanced Firearms Safety Compliance System. Massachusetts launched its Responsible Ownership Verification Program. For 8 weeks following Carson, these replacement systems went into operation in 14 states while millions of gun owners were told that the old permits were gone, but the new systems were mandatory. On June 18, 2026, the Supreme Court responded with Coleman versus New York, a 7-2 shadow docket emergency ruling that went further than Carson, further than Anderson versus Bonta, further than anything the court has issued in the Second Amendment context, and declared every single prior approval system, replacement scheme, certification requirement, enrollment mandate, and government permission prerequisite for purchasing, possessing, or carrying firearms in America unconstitutional, void, and unenforceable, not in 30 days, not subject to a transition period, immediately. June 18, 2026. Subscribe right now because Coleman versus New York is the emergency ruling gun owners have been waiting for and that state officials in 14 states spent 8 weeks hoping would never come. And what it says, what it does, and what it means for your life starting today is something every gun owner in America needs to understand before their next firearm-related decision. The sequence that led to Coleman, Carson versus United States, June 3, 2026. Struck down all permit systems in all 50 states under the Second Amendment's shall not be infringed command. Within 48 hours, 14 states began activating pre-drafted replacement legislation under different names imposing the same functional requirements. Government-issued approval documents before purchase or carry, training mandates, fees, processing delays, and government databases. David Coleman, a New York resident, attempted to purchase a handgun on June 5, 2 days after Carson, and was told by the dealer that New York's Community Safety Firearms Enrollment required him to first enroll and receive approval. Coleman filed an emergency constitutional challenge in the Southern District of New York on June 6th. The district court denied emergency relief, finding the CSFE was a different system from the carry permit Carson struck down. Coleman filed an emergency application to the Supreme Court on June 8th. The Supreme Court issued Coleman versus New York on June 18th, with a 7-justice majority opinion authored by Justice Amy Coney Barrett. Number 1, what Coleman holds and why it goes further than everything before it. The core holding. The Second Amendment prohibits any form of prior approval requirement as a precondition for purchasing, possessing, or carrying firearms by law-abiding citizens. This prohibition extends to every mechanism, regardless of label, that requires a citizen to receive government-issued authorization before exercising Second Amendment rights. The prohibition is absolute within its scope. If a system requires government permission before rights exercise, it violates the Second Amendment and is void from its inception, retroactive to the date of each system's enactment, not from the date of Coleman's issuance. The regardless of label principle, the most significant legal innovation in Coleman is what Justice Barrett calls the regardless of label principle. The constitutional question is not what the state calls its system, but what the system does. If it requires citizens to obtain government approval before purchasing, possessing, or carrying firearms, it conditions a constitutional right on government permission, violating the Second Amendment's command regardless of whether the permission document is called a permit, certification, enrollment, registry, or any other term. Barrett writes, "The constitutional question is not what the state labels the permission document, but whether the document is required. If it is a prior approval requirement. If it is a prior approval requirement, it violates the Second Amendment." This principle permanently eliminates the replacement system strategy. States cannot defeat Coleman by renaming their systems. Why 7 justices agreed? The 7-justice Coleman majority, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, and Justice Kagan, reflects the same dynamic that produced Morrison's near unanimity. Broad agreement that the state defiance pattern following Carson was unacceptable. Justice Kagan's concurrence is the most politically significant. A state that responds to a Supreme Court decision by immediately enacting legislation designed to accomplish the same result the court just prohibited is not engaging in good faith implementation of constitutional law. It is treating this court's authority as advisory. We cannot permit that. The two dissenters, Sotomayor and Jackson, argued the replacement systems were genuinely different in character from the permit systems Carson struck down, and that the court should have used normal appellate process rather than emergency shadow docket action. The retroactivity holding. Coleman holds that every void prior approval system is void from the date of its enactment, not from June 18th. Fees collected under these systems are refundable. Denials issued under these systems were unconstitutional rights deprivations from the date of denial. Citizens who were denied purchase or carry rights have civil rights claims retroactive to the date of each unconstitutional denial. This retroactivity holding creates the most significant civil rights damages exposure for state officials in Second Amendment history. Number 2. The specific systems Coleman declared void. California's Firearm Responsibility Certification, FRC. Enacted June 7, 2026, 4 days after Carson, through emergency administrative action. Required $750 liability insurance, 40-hour safety course, $800 to $1,200, 4 character references with in-person interviews, psychological evaluation, $400, 6-month minimum processing, sensitive places covering all public transit, all parks, all government property, void from June 7th. Every FRC fee paid is subject to refund. Every FRC denial was an unconstitutional rights deprivation from that date. New York's Community Safety Firearms Enrollment, CSFE. Enacted June 6, 2026. The specific system Coleman challenged. Required state database enrollment, character references, social media review, $200 enrollment fee, good moral character determination with 8 to 12-month processing. Void from June 6th. The primary target of Barrett's majority opinion. Illinois' Responsible Citizen Firearm Registry, RCFR, enacted June 8, 2026, replacing the FOID card with identical application and processing requirements under a new name. Justice Barrett dedicates 3 pages to the RCFR as the paradigmatic example of the regardless of label principle. Illinois argued the RCFR was constitutionally different from FOID because it used different terminology. The majority found this functionally irrelevant. Void from June 8th. New Jersey's Enhanced Firearms Safety Compliance, EFSC, enacted June 10, 2026, included in-home safety inspection as a precondition of approval. A requirement the majority noted presents constitutional problems under both the Second and Fourth Amendments. Void from June 10th. Massachusetts Responsible Ownership Verification Program, ROVP, enacted June 12, 2026, with mental health screening requirements, 3 character references, community notification requirements, and 9-month processing. Void from June 12th. All other replacement systems. The regardless of label principle applies to every state system not specifically named. Colorado, Oregon, Washington, Minnesota, Michigan replacement systems, and any future systems meeting the functional test. Every prior approval system in America is void under Coleman. Number 3. What Coleman means for purchases, dealers, and pending applications. Purchases starting June 18th. Walk into any licensed FFL in any of the 50 states. Complete ATF Form 4473. Pass the federal NEX background check. Take your firearm home. No state-issued certification. No enrollment confirmation. No training certificate. No government approval document of any kind. The complete legal requirement is Form 4473 NICS background check. Federal age compliance, 21 for handguns, 18 for long guns. Prohibited persons compliance. Everything a state has imposed between you and your firearm beyond these requirements is void under Coleman. Carry starting June 18th. Constitutional carry is the law of the land in all 50 states. No permit required to carry concealed or openly in any state. If you are a law-abiding citizen who is not a prohibited person under federal law, you can carry a firearm in public without seeking government permission anywhere in America. Genuine sensitive places, schools, active courthouses, government buildings with security screening, establishments primarily serving alcohol, retain their historically grounded restrictions. But the permission document is gone. Dealer obligations and protections. Dealers must continue NICS background checks, This is a minimal burden Coleman explicitly preserves. Dealers must comply with federal age requirements and prohibited persons prohibitions. Dealers must maintain bound book records. But dealers cannot be required to collect state-issued certification documents, enrollment confirmations, training certificates, or any other state approval documentation as a precondition of sale. Dealers who complete sales without state certification verification are protected from state enforcement action. Dealers who continue to require state certification from customers are potentially exposing themselves to civil rights liability under Section 1983. Pending applications and fees paid. If you applied for any void replacement system and paid fees, you are entitled to a refund. The fee was collected under an unconstitutional system void from its enactment. Send a written demand to the collecting state agency, citing Coleman v. New York, June 18, 2026. If the state fails to refund within 30 days, you have a federal civil rights claim for return of fees collected under an unconstitutional system. Pending denials. If you were denied purchase or carry rights under any replacement system, that denial was an unconstitutional deprivation retroactive to its date. You have Section 1983 claims for the period of unconstitutional denial. Consult a civil rights attorney about specific claims, potential damages, and statute of limitations in your jurisdiction. Number 4. The damages and enforcement implications. Civil rights claims under 42 U.S.C. Section 1983. Citizens denied Second Amendment rights under any Coleman void system have federal civil rights claims against enforcing officials. Section 1983 claims can seek compensatory damages for the period of unconstitutional rights denial, consequential damages for compliance costs, training fees, application fees, psychological evaluation costs, attorney fees, punitive damages against officials who enforced systems knowing they were designed to circumvent Carson, and attorney's fees under Section 1988, meaning your attorney can be paid by the state when you win, making these claims viable even for relatively small individual damages. Qualified immunity eliminated. Coleman clearly establishes that all prior approval systems are unconstitutional, eliminating qualified immunity for enforcement conduct after June 18th. For the 15 days between Carson and Coleman, qualified immunity arguments are weaker given that replacement systems were designed specifically to circumvent Carson's holding. Courts will evaluate whether the constitutional violation was clearly established during that window. Class action potential. The number of citizens who paid fees for replacement systems, were denied purchases, or were required to go through replacement processes makes Coleman one of the most significant class action generating decisions in federal civil rights history. Gun rights organizations are coordinating with class action plaintiffs' attorneys in California, New York, Illinois, New Jersey, and Massachusetts. Preserve your payment records, correspondence, denial notices, and all documentation of interaction with replacement systems. Your records may be valuable in class actions returning not just individual fees but substantial damages for the period of unconstitutional rights deprivation. State Treasury exposure. California's FRC collected $750 plus in fees from every applicant and imposed $800 to $1,200 in required training costs over 15 days of operation before Coleman. The aggregate fee collection across 14 states, times the damages multiplier for civil rights violations, creates fiscal exposure these states have not calculated, and that will shape their response to Supreme Court gun rights decisions going forward. Number 5. State responses and the political fallout. California. Governor Newsom described Coleman as an unconscionable abdication of judicial responsibility and announced immediate FRC enforcement cessation while advancing alternative legislation, ammunition background checks, enhanced point-of-sale screening, expanded sensitive place designations, targeting the regulatory space Coleman leaves open. California simultaneously filed motions challenging Coleman's retroactivity holding on fee refunds. New York, Governor Hochul announced implementation compliance while simultaneously filing a motion for emergency clarification of Coleman's scope, arguing CSFE components function differently from prior approval systems. The Supreme Court denied the motion without comment. Illinois. Attorney General Raoul announced compliance while pursuing qualified immunity arguments in pending litigation. arguing RCFR enforcement between Carson and Coleman was protected because Carson's issuance did not clearly establish unconstitutionality of systems with structural differences from traditional permits. Free states, Republican governors in compliant states welcomed Coleman. Texas Governor Abbott. The Supreme Court has spoken again clearly for the 7th time in recent years. The Second Amendment means what it says. Florida Governor DeSantis. Florida gun owners have nothing to fear because Florida never tried to undermine Carson in the first place. Legislative response across affected states. Multiple state legislatures are convening emergency sessions to identify surviving regulatory approaches, ammunition, background checks, sensitive place designations, storage requirements, enhanced point-of-sale verification that pass the Coleman. Does it require government approval before exercise? Functional test. This regulatory space is narrow compared to prior permit systems and replacement schemes, but it is what remains after Coleman. Number 6. What every gun owner must do in the next 30 days. If you possess a replacement system document, you do not need it. Effective June 18th, it is not a legal requirement. Carry without it. Purchase without it. If law enforcement asks for a permit or certification, you can state that Coleman versus New York, June 18, 2026, declared all prior approval systems void. If you are detained or arrested for exercising constitutional rights, Coleman protects. Contact a civil rights attorney immediately. If you have been waiting to make a purchase, go to your nearest licensed FFL today. Bring valid government ID, complete Form 4473. Pass NICS. No state documentation required. If the dealer asks for void state documentation, inform them of Coleman's holding and their legal protection in completing the sale without it. If you paid fees for any replacement system, identify every fee paid, FRC application fees, required training course costs, psychological evaluation fees, enrollment fees, processing fees. Send written demands citing Coleman versus New York to the collecting state agency. If refunds are not received within 30 days, contact a civil rights attorney or gun rights organization coordinating class actions. If you were denied under any replacement system, document the denial notice. Identify the date and specific system that issued the denial. Contact Firearms Policy Coalition, fpclaw.org, Second Amendment Foundation, saf.org, or Gun Owners of America, gunowners.org. These organizations are coordinating Section 1983 class actions and need documented plaintiffs. If you are a dealer, immediately update your compliance procedures. No state-issued certification documents required from customers. Only Form 4473, NICS, age verification, prohibited persons compliance. Document your Coleman compliance effective June 18th. If state officials contact you about compliance with void replacement system requirements, cite Coleman versus New York and note that Supreme Court precedent requires completion of sales without void state documentation. If you live in a non-replacement system state, your state was already fully compliant after Carson and remains so under Coleman. You have been exercising your rights correctly since Carson and continue to do so. Coleman confirms your position and eliminates any uncertainty about state efforts to impose replacement systems in your jurisdiction. Number 7. What Coleman means for the future of gun law in America. The end of the prior approval era, permanently, Coleman, Carson, and Morrison together establish an absolutely clear constitutional principle that no prior approval system can survive. The government can regulate the transaction, instant background check, age verification, restrict who can own firearms, prohibited persons through due process, restrict where firearms can be carried, genuine sensitive places, and regulate storage and use after the fact. What it cannot do, ever, in any form, under any label, is require citizens to obtain government permission before exercising Second Amendment rights. The regardless of label principle eliminates even the naming strategy for future circumvention. The compliance monitoring architecture. Coleman integrates into Morrison's compliance monitoring framework. The 90-day compliance deadline, expedited compliance petition review, DOJ congressional reporting, and full enforcement remedies, personal liability, federal monitors, federal receivership, all apply to states that attempt new prior approval systems after Coleman. The court has now built a complete enforcement architecture that did not exist in the prior decade of Second Amendment litigation. The Section 1983 ecosystem. The combination of Coleman's retroactivity holding, regardless of label principle applied retroactively to system enactment dates, and qualified immunity elimination for post-Carson enforcement creates the most significant Section 1983 firearms ecosystem in American legal history. Class actions will be massive. Discovery will reveal the extent to which state officials designed replacement systems, knowing they were unconstitutional. Documented bad faith will drive punitive damages and potentially criminal civil rights referrals. Justice Kagan's political significance. Kagan joining the Coleman majority creates a 7-justice constitutional consensus that disrupts the partisan alignment that has defined Second Amendment law for decades. For decades, every major gun rights expansion came from Republican appointees over Democratic dissent. Kagan's Coleman concurrence establishes that deliberate constitutional evasion, regulatory workarounds designed to recreate prohibited outcomes under different labels, will face 7-justice resistance regardless of the political valence of the underlying right. This realignment has implications beyond Second Amendment law for how courts evaluate constitutional bad faith generally. Bottom line, Coleman versus New York, June 18, 2026. 7-2. Every prior approval system, in every form, under every label, in every state, is void under the Second Amendment's shall not be infringed command, retroactive to the date of each system's enactment. What Coleman holds: any system requiring government approval before purchasing, possessing, or carrying firearms is void regardless of label. The regardless of label principle is permanent. Retroactivity creates civil rights claims from the date of each unconstitutional denial, not from June 18th. Systems void: California FRC, void June 7th. New York CSFE, void June 6th. Illinois RCFR, void June 8th. New Jersey EFSC, void June 10th. Massachusetts ROVP, void June 12th. All other replacement systems in all other states, void from their enactment dates. Starting June 18th, purchase with only Form 4, 473, and NICS. Carry without any permit or certification. Travel through any state without government approval documents. Demand refunds of fees paid to void systems. Document denials and contact FPC SAF GOA for class action participation. Dealers: complete sales with only federal requirements. No void state documentation. Document Coleman compliance. Report state enforcement of void requirements. Subscribe because Coleman versus New York is generating Section 1983 litigation, class action filings, state legislative emergency sessions, and compliance monitoring enforcement actions simultaneously across 14 states, and every development in that process directly affects your rights, your potential refunds, and the permanent protection that 7 justices confirmed on June 18th. Gun permits are over. Replacement schemes are over. Coleman made sure of it permanently for all 50 states, effective today.